When we moved back from Japan to the United States, we encountered what felt like an ever-tightening noose of gun violence. As we drove out from Texas towards our new duty station, we witnessed scores of police officers jetting down the freeway in the opposite direction, racing toward Uvalde. When we arrived in Virginia, the University of Virginia experienced its own school shooting, targeting football player classmates returning from a field trip to see The Color Purple in Richmond. It was an abrupt reintegration to the American fascination with firearms. I don't know if the socialization of young boys to idolize and play with guns has anything to do with the prevalence of violence, and without CDC research into the gun violence epidemic that plagues this country, it's unlikely we'll have real or meaningful answers beyond my conjecture or yours. It very well could be that boys are socialized to pretend and play with guns. It could be the male loneliness epidemic rearing its head. It could be the lack of sufficient mental health resources. Maybe it's all of those things, but maybe, just maybe, it's the guns, that ready access. And I've discussed men playing around with guns on this podcast before, specifically in episode 39, the Maybane case. But Lance Corporal Robbins brings us right back to this same conundrum. He opted to up the ante on his gunplay, stealing a laser sight from the Marine Corps so he could have even more fun? In predictable fashion, playing around with loaded guns went tragically wrong and landed Robbins in a court-martial. This is Conduct Unbecoming. I'm Erin, and I'm your host. I'm going to flip the structure of this episode a bit. I don't think it behooves us to get through the facts and then dip our toe into the legal issues. We have to mix it all together like a chowder and tackle it all at once. Lance Corporal Connor Robbins and his friends, who we're going to call Bill and Steve, served together as Marines at Camp Lejeune in North Carolina. Robbins and Bill both worked in the armory, and it seems that Steve's job was unimportant to this story. And this is where I'm going to take things wildly out of order and give away the ending. For his role in the crime that we're talking about today, Robbins received a sentence of confinement for 120 days, which I feel compelled to observe is just 4 months, reduction to E1 and a bad conduct discharge. Bill, for his part, received non-judicial punishment. And on appeal, Robbins complained that his sentence was so much worse than Bill's, and they were co-conspirators. To him, that felt incredibly unfair, so he argued that his sentence was inappropriately disparate. When the military courts of appeal look to disparate sentences, they consider whether the cases were closely related, whether the cases resulted in highly disparate sentences, and whether there is a rational basis for the differences in the adjudged sentences. A lot of things can come together to form that rational basis, including the various roles the defendants played, but also what sort of resolution the case came to. And those various courts of criminal appeals in the military justice system have wide discretion to determine whether a sentence is appropriate. The discussion section of the Navy and Marine Corps Court of Criminal Appeals opinion starts in a manner that I find delightfully straightforward and to the point. It's a shame that this is not a published opinion, because I find that when I'm conducting legal research, the most obvious and straightforward propositions are the hardest ones to find. So I can't believe that we're depriving future briefs of such clear recitation of the laws. The first 3 sentences of that discussion section read, Robbins shot another Marine in the head. Bill did not shoot another Marine in the head. The disparate dispositions of their misconduct are justified since Robbins shot another Marine in the head, and Bill did not shoot another Marine in the head. This is when you can play the record scratch and say, I bet you're wondering how we arrived here, and rewind. But I maintain a pretty light hand when editing, so you'll have to use your imagination. Let's walk back to the beginning together. Robbins and Bill both worked in the armory. They handled a number of weapons and devices, and decided that some of them should be, shall we say, reappropriated. Specifically, they were interested in acquiring PEC-15 laser aiming devices. Those have an approximately $2,000 price tag. So together they planned their heist and executed it, stealing 2 PEC-15 laser scopes. With their contraband in tow, Robbins and Bill drove over to Steve's house. The 3 men planned an evening of tinkering with their personal firearms. In line with that plan, Robbins set out about disassembling his pistol. Without chucking the chamber, Robbins began pulling the pieces apart, squeezing back on the trigger. A shot rang out before a bullet struck Steve in the head. The shot was not fatal, but Steve lost his right eye and continues to suffer the after effects of such a grave injury. Prosecutors weighed what happened that day, charging Robbins with conspiracy to wrongfully appropriate military property, aiding and abetting Bill in wrongfully appropriating that property, dereliction of duty resulting in grievous bodily harm, and negligent discharge of a firearm. Bill faced his own possible court-martial, but was offered and accepted non-judicial punishment for his role in the conspiracy with Robbins, the burglary of the armory, larceny of the PEC-15s, and other unrelated larceny. He agreed to testify at Robbins's court-martial and otherwise cooperate in the investigation related to Steve sustaining such a serious injury. This wasn't a one-sided deal. This wasn't Bill volunteering to do the right thing for purely selfless reasons. The convening authority agreed to withdraw and dismiss the charges against Bill in exchange for his cooperation. Robbins opted for a bench trial and entered a mixed plea without a plea agreement. Specifically, he pled guilty to conspiracy and negligent discharge and not guilty to the remaining offenses. Following a court-martial on the merits, the military judge acquitted Robbins of wrongfully appropriating those laser scopes and of negligent dereliction of duty. So when Robbins challenged his sentence as inappropriately severe, as disparate from Bill's sentence, the NMCCA highlighted what was obvious. Robbins shot a Marine in the head, and Bill did not. The NMCCA was unconvinced that Bill's non-judicial punishment was unreasonably disparate from Robbins's punishment because, again, Robbins caused a Marine to lose his eye and suffer permanent damage, and Bill did not. And if you heard this fact pattern, Marines playing with guns and someone being shot in the head, and felt a faint sensation of scratching at the back of your mind, you're thinking of episode 39, the U.S. versus Mabane. And while that is a separate case, the little reminder at the back of your head is well-timed, and we should talk about it. As a 10,000-foot summary, in Mabane, 5 young men were hanging out, by which I mean drinking and playing with guns, dry-firing them while ignoring the first rule of gun safety and pointing them at each other. When they were done showing off Edmund Mabane's firearms, they tucked a lever-action rifle behind a recliner, a pistol between a wall and a couch, and a second pistol under the coffee table. One of the young men fiddled with ammunition and a magazine on the TV stand before Mabane asked for the accoutrements so he could go put everything away upstairs. Mabane grabbed the pistol from under the coffee table, loaded the magazine, chambered around, and inserted an extra bullet into the magazine so the gun was truly fully loaded. But instead of putting the firearm away, he tucked it into his waistband. Later, while wrestling with De Leon, Mabane pulled the gun from his waistband, placed it against De Leon's head, and pulled the trigger. Another Marine had already jumped up to stop Mabane, knowing there were live rounds in the gun, but it was too late. To responding investigators, Mabane claimed that De Leon had reached into the sofa, pulled out a pistol, held it to the front of his own head, and fired. Because of their drinking and statements to investigators that have now been adjudicated false, it wasn't immediately clear who shot and killed Michael De Leon. One young man, Wald, confessed following what seems to be some rather suggestive questioning from investigators. The initial confession was pretty watery, and he said that if he shot De Leon, he didn't remember doing it, but then later suggested that perhaps he blocked it out, but that if he knew he did it, he would say it. Agents leveraged Wald's relationship with his older sister and the existence of De Leon's younger sister, trying to appeal to him as a sibling. When agents left the interview room, he whispered to himself that it wasn't him. After they returned, he said, "I guess I did it," and proceeded to spiral, word-vomiting things that sounded vaguely guilty, but don't really seem to constitute details. In response to the question, "Did you pull the trigger?" Wald said, "I believe so. I swear I put down my beer, looked at the TV, and that's when the shot got off," which is pretty different than saying, "I looked at the TV and fired the shot." Agents kept asking questions, and Wald seemed to start to conflate his earlier dry firing of the gun, which he remembered doing, with De Leon's death. At the urging of the agents, Wald penned a letter to De Leon's family, in which he apologized. While Wald was in custody, another of the young men who was there that night, one of the few witnesses to De Leon's death, came forward. He said based on where everyone was sitting, the only way that Wald could have fired the shot was if the entrance wound was at the back of De Leon's head. And it wasn't. The wound to the back of De Leon's head was the exit wound. This detail led investigators back to Mabane. 12 days after his interview, Wald recanted the confession. To explain himself, he said that he'd made a false confession because he was scared and sleep-deprived and just wanted the questions to stop. At court-martial, the military judge excluded evidence of the confession so as to not confuse the panel. For more detail than that, definitely go give episode 39 a listen, but do so with the proviso that a keen-eared listener let me know that I may have gotten mixed up on where two of the Marines were sitting when the gun went off. I've chalked that up to a somewhat confusing decision from the NMCCA to give everyone other than Mabane a pseudonym, even though all of them faced charges following De Leon's death. I'm bringing all of this up about Mabane because the Court of Appeal for the Armed Forces recently released its opinion on the matter. Mabane renewed a Sixth Amendment argument to CAF, asserting the military judge violated his Sixth Amendment right to present evidence of Wald's confession. The military judge denied his motion to present a recording of Wald's confession because the confession could not be corroborated by the record. It came after suggestive questioning in a second interview. His mental state was not reliable, and, fourth, that it was false. In the alternative, the military judge had ruled that the confession would serve to mislead the members and waste time in violation of Military Rule of Evidence 403. Decisions around the admissibility of evidence is reviewed on appeal to determine if a judge abused their discretion in making the ruling, looking to whether the findings of fact are not supported by the record, whether the judge failed to consider facts, whether they used incorrect legal principles, or whether their application of the correct legal principles is clearly unreasonable. On review, CAF carried this abuse of discretion standard alongside a question of whether excluding the apparently false confession violated Mabane's constitutional right, focusing on whether the military judge's application of the evidentiary rule, quote, infringes upon a weighty interest of the accused and is arbitrary or disproportionate to the purpose the rule is designed to serve. CAF determined that the exclusion of the apparently false confession and that handwritten letter to De Leon's family infringed on Mabane's weighty interest of presenting a defense centered on the contention that he did not fatally shoot De Leon, and that Wald did. When CAF looked to whether the judge abused their discretion when they excluded the confession, CAF concluded they had. They believed Wald's confession was trustworthy because it was made in close temporal proximity to the crime. The confession was corroborated by other evidence of him dry firing the gun at De Leon earlier in the evening, and there was gunshot residue on Wald when he was later tested. The confession was clearly against his interest, and Wald was subject to cross-examination at Maybane's trial. I want to anchor what I'm about to say in the fact that I have not seen the interview and confession. Based on how the NMCCA and even CAF described it, it doesn't seem like the confession could overcome the specter of coercion. So it feels kind of weird to go, no, this seems reliable, and allow it in for the purposes of Maybane's defense. I understand what CAF has to say about how problematic it was or may have been for the military judge to find conclusively that the confession was false. But even if the judge had left that fourth factor out, it doesn't seem like CAF thought the ruling could be saved. In part because CAF went on to conclude that the interview was appropriate, which is to say, not coercive. Because the majority opinion from CAF concluded that the military judge committed reversible error by excluding the confession and letter, they reversed the NMCCA and remanded the matter, authorizing a new hearing. That means if the Marine Corps would like to keep Maybane convicted of involuntary manslaughter, they will have to retry the case. I'm sure you clocked that I mentioned that was the majority opinion, so I should note that there was a two-judge dissent that looked to whether Wald's statements were in fact inadmissible hearsay. They were out-of-court statements that Maybane wanted to offer for the truth of Wald as the triggerman. The author of the dissent dug into a lot of the same guarantees of trustworthiness that gave the military judge pause, ultimately concluding that Wald's hearsay statements were appropriately excluded. The dissent was unpersuaded that the untrustworthiness of the statements could somehow implicate a Sixth Amendment claim. If the interview and confessions are as coercive as the summaries seem to imply, I'd imagine that the testimony from other witnesses, the location of the entrance and exit wounds, and that footage of the confession lead a future panel to a similar result. It's possible, but it seems unlikely, that Maybane could accept some manner of plea agreement to avoid trial or reduce his carceral term. If I hear of any other updates on Maybane, I will, of course, share them here. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we tackle what I perceive to be our creepiest case yet. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense, or by their new preferred name, the Department of War.